Welcome to Petronoia, the podcast that cuts through the noise of the energy debate. Hosted by Dan Romeo, this show takes complex energy issues, strips away the agendas, and delivers clear fact-based insights. Whether you're an industry expert or simply looking for a balanced perspective, Petronoia brings clarity to the conversation. Each episode, Dan breaks down key topics, from U.S. energy independence to global policy impacts, focusing on the facts rather than the rhetoric, helping listeners make sense of the energy landscape. This is Petronoia, where we separate fact from fiction to fuel-informed discussions.
Welcome to Petronoia. I'm Dan Romeo. I am joined by good friend Marcella Burke. She's running point at the Burke Law Group. I figured it was a good time to get her on the show for a variety of reasons, particularly with like this endangerment finding. Whenever there's a legal question, I call Marcella anyway. So we got to talking, and I was like, just get on the podcast. So Marcella, thank you so much for the time. Before we kick it off, would love for you to just give a background. Love your background, love your story. And so, for the audience, why don't you give sort of how did you get here, and then we can dive right down into the good stuff.
Sure. Dan, thanks for having me. I'm Marcella Burke. I'm a lawyer in Houston, Texas, and I run the Burke Law Group. And we have about 20 lawyers and do litigation mostly, commercial litigation, a lot of industrial, oil and gas, regulatory compliance litigation, and we have a group of 7 lawyers dedicated just to environmental regulation, and we do a lot of work with the EPA, and so the endangerment finding is something that we have been working with and on for years and years. I served twice in the Trump administration, 45. I was at EPA, and then I was at the Department of Interior. And so I was in the legal teams and the senior executive service at both agencies. And so we do a lot of work with EPA and different government agencies on oil and gas issues. So this has definitely been a big topic, very hot, since the Obama administration. So just very happy to talk to you about it.
Yeah, I always feel, if I'm being honest, I always feel dumb when I read these things. Like, I'm just not very good at just legal jargon. Maybe it's a good idea just to set the table for us non-lawyers or people who don't understand sort of like the history. Can you take the time just to break down the origination of the endangerment, and then how we got to where we're at today?
Sure. So the endangerment finding is a term of art, and it comes from statutory language. So it sort of goes back to, your high school civics class, but Congress put out the Clean Air Act, and it's a Clean Air Act is like a very general statute, and it says, hey, Congress wants the executive branch, the president, to keep the air clean in America. So he asked the EPA, the Environmental Protection Agency, to be their job, and they put out regulations. And so that's sort of the high level, where did this come from? And the language in the statute says that the EPA should be regulating anything that could be endangering the health. So an endangerment finding would be a finding by an agency like the EPA saying, hey, X, Y, or Z is dangerous, we should regulate this, or we have to regulate this. So the question, what's interesting about this particular endangerment finding, which is about CO₂ and greenhouse gases, is whether CO₂, carbon dioxide, the basis of all human life. If you were to lose CO₂ at the same time that you lost water, you would die instantly, right? You can live 3 days without water. CO₂, you need that. So it's sort of a shocking thing. It'd be like if EPA were to tomorrow say, we're going to actually regulate water vapor, or we're going to regulate one of the most ubiquitous things in the atmosphere is CO₂. And we've come out with, in 2009, in the Obama administration, a finding that the most ubiquitous substance on the planet is actually an endangerment to human health. And it's based on a bunch of research and studies. And so that's sort of what happened here. There was a cause and contribution finding that came out with the endangerment finding back then. Okay. No one really talks about that as much. But just so you know, basically, the issue is whether global climate change can reasonably be anticipated to endanger human health or welfare at some point in the future. And 2, do GHG emissions from cars contribute to global CO₂ concentrations on some level? And so those 2 findings are sort of what's been at issue, and there's been debate ever since then on this on this issue. And why do people feel stupid? Because usually science is being debated, and we're used to this by now. But think about 2009. Experts were taken a lot more seriously, and they would say complicated things, and then they'd be like, we're experts, and then you kind of felt stupid. Now people are kind of sick of experts shoving stuff down their throat, and we've reached a point where this administration, the second Trump administration, is forcing sort of the people who support the idea that CO2 is a toxin to really go back and prove it. Like, you're going to really have, so we'll get more into this if you have other questions for me, but high level, that's what happened here. This Trump administration said, we're going to go back and we're going to look at this, and we're going to see if there actually is enough data and science, actual science, that tells us that CO2 could be a poison.
So in many ways, and you hear this argument all the time, it's we're scrapping this because we don't like it, right? And to a certain extent, people don't like it. I get that part. But the more and more I learn about this, and you kind of touched upon it, it seems more, it's like, you know what? We're just gonna tear the house down. We're not renovating the kitchen or fixing up the bathroom. We're tearing the house down, and we're starting from scratch. And the onus is on the scientific community to reestablish the data and the facts and the evidence so that we can just create more sound policy that actually balances regulation with the ability to run an efficient business. Is that a good way of characterizing from a layman's perspective?
It's 2025, where they decided to reevaluate a 2009 finding with new research, new data. And there's just been a lot of people that have come out that you and I are aware of, but it's like the Schellenbergers of the world who've just come out and said, let me look at that data. Let me look at the science. Let me look at the, formulas that you're using. And there's just been so much that's come out challenging the climate change, quote, science, that now, 2025, let's have another look.
So there's also a variety of just sort of adjacent legal cases, right? You have Chevron deference. You have Massachusetts versus EPA, which was before the 2009 endangerment. So once again, to kind of just connect the dots, can you break out the intent and the outcome of Massachusetts versus EPA, how this ties in with Chevron deference, and then where this kind of interplays with the endangerment repeal?
Yeah, so Massachusetts versus EPA is like the big case that kind of got us here. It was a 2007 Supreme Court case, and the question was whether do greenhouse gases fit within the Clean Air Act's very broad definition of air pollutant. So remember, I'd said that the Clean Air Act, there's arguments out there that the Clean Air Act is unconstitutional because it's unconstitutionally vague. It's just too broad of a mandate. Like, go make sure there's not air pollutants in the air type thing. That's basically how it's drafted. Right. So anyway, it's in 2007, the Supreme Court said in Massachusetts versus EPA that greenhouse gases can fit within this incredibly broad definition of air pollutant. And so this led the EPA to regulate carbon dioxide for the first time. The court also said that EPA had to do two things. One, determine that CO2 emissions would reasonably be anticipated to endanger public health or welfare, or two, explain why the science is too uncertain to make that determination. So suddenly EPA is like in this game, like the scientific game of whether CO2 is an air pollutant. And Scalia was involved, and he rightly noted in his dissent that it's not clear that the Clean Air Act's definition of air pollutant fits CO2. So from the very beginning in 2007, before the 2009 finding, it was already highly questionable whether or not, CO2 is a pollutant. And it's so ubiquitous. It's a naturally occurring gas. The court failed to address the crucial question of whether CO2 pollutes or adulterates, Scalia said, the air at all. So that's always been an issue. In 2009, the EPA made a proposed endangerment finding, invited extensive comment, built what's called an administrative record, leaning then on the current scientific modeling and the climate studies. And so that's the some of the data that's being challenged today. Later that year, EPA made their final endangerment, and then it was that cause or contribution finding, the two of them. And those set the stage for the first major greenhouse gas vehicle standards very shortly thereafter, and set off the broader cascade of regulations. questions about permitting and sort of how can a globally present gas be regulated under the United States, that kind of thing. That all started with Massachusetts versus EPA 2007, that carbon dioxide is a pollutant.
Yeah, that's the thing that drives me a little bit insane is like Europe, for example, we'll take the extreme version, is Europe is, I would say, very aggressive on the climate change mitigation and the CO2 kind of mandates, but they're 4% of global emissions. So I always ask the question, and I think it's a fair question, that if Europe went net zero tomorrow, it's kind of like, who cares? Now, I'm not saying don't do anything, but certainly you see like all these ramifications and sort of maybe unintended or intended, whatever, but nonetheless consequences put in place because they're pursuing this aspirational goal, which at the end of the day, it's like, well, it's 4% of global emissions. So that's like, hey, I want to lose 10 pounds. I'm just going to cut off my leg. Like I'd rather just lose the 10 pounds. You know what I'm saying? Like, don't want to chop off an appendage. The other thing too that is confusing, at least to me, but in the conversation, like, what is actually being repealed? Like, you know, you bring up a good point. Is like the language. Like, you get like Clean Air Act, right? No one is going to say I'm against Clean Air Act. They're going to say, well, look, like this is too ambiguous or it's too hard to follow. So it's not that we're against clean air. It's just you need to clarify what we're actually doing here. In that respect, you know, for the, once again, the layman, what is being repealed? Is it a reinterpretation? Are we taking a step back? I mean, you kind of alluded to it, but I think that's an important question, or to clarify, like, what are we doing here?
So it's like the endangerment finding itself, it's a little bit of policy, it's a little bit of legal reinterpretation. Okay. It's sort of an all of the above. From a legal standpoint, what's being repealed is the Clean Air Act's endangerment framework as currently understood by the EPA. EPA is trying to remove the agency's own determination that CO2's current and projected concentrations threaten the public. It's saying that its finding is no longer valid. The 2009 finding is repealed, no longer valid based on what we know in 2025. Practically speaking, it's also a huge policy shift. It changes how government is working to address greenhouse gases going forward. So agencies make policy in lots of ways. They, the president can put out an executive order, and then from there, each agency can respond to it. And, agency administrators and senior officials can give speeches, and Congress can make laws. There's all sorts of things that we do to make policy. Agencies make policy in specifically, though, in their rulemakings. And so what happened here is this agency decided to make EPA to make this rule on the endangerment finding. And so this administration is signaling a different view of the risk of framing and how the Clean Air Act should function for climate policy, to go back to its original role of local pollution mitigation. This is not something that can be done even by EPA well. And so EPA is doing something very remarkable, actually, on a policy level. It's saying it doesn't have the power to regulate CO2 and other greenhouse gases as public health risks under the current law. So that's really interesting, and it kind of goes to your comment about, Europe. I mean, if the United States were to completely go lights out, we would not, and we would produce zero energy at all. Right. Going forward, this would not put a dent in the actual carbon numbers because of Asia and India and China, and so anyway, it's sort of those are policy arguments too. I mean, they're very practical, common sense arguments. They're not necessarily legal arguments. We make those arguments in our briefs to try to persuade the court that this is the reasonable thing to do, but ultimately, this is a legal issue. That goes through the courts.
Yeah, I was fortunate enough. So it was funny. So Fortune, this is how it usually works. Fortune magazine calls Dan Pickering, and Dan is like, I don't want to talk to Fortune, talk to Romeo. And of course, they ask me, well, what do you think about it? And very respectfully, I'm like, I don't think this is a big deal. And they're sort of a little thrown off by that. Like, why don't you think it's a big deal? I'm like, well, I think the industry was already preparing just to be even keel and to stay immune from, let's just call it political wins, but also this is going to find its way into the courts. Like this, it is inevitably going to be, there's going to be a lawsuit. So number one, and by your head nod, I think you agree with me, but taking devil's advocate perspective, like what's the most vulnerable part of the decree? If decree is even the right word, like what's of the ruling?
Well, so it's just really difficult to unwind like a foundational finding. So the endangerment finding is seen, like it or not, as sort of foundational to what the EPA is doing and has been doing for almost 20 years. And so it's a huge amount of work went into sort of endorsing the 2009 endangerment finding. And as you know, on the pro climate change, I would say climate alarmism side of the House, this has become a huge issue. It's a huge political issue. People vote based on this issue, especially on the left, the Democratic Party. This is just one of their top issues. And so it's not necessarily a Republican top 3 issue, right? And so that's where it's tough. Politically speaking, that we keep getting further and further down the line on what's climate change and on things like CO₂, because the left is more interested in it than the right, frankly, in some ways. So unwinding.
Not to cut you off real quick, I'll give you a real life example of that. So this came out on the wire, like whatever time, 10 a.m., whatever. At like about 2 hours later, I get an email from Ceres, right, the environmental NGO. They're like, please donate to the cause. And it's like this very sort of apocalyptic message of like the end of the world is coming. It's actually, I mean, frankly, in my opinion, it was a little bit inappropriate, but it was like, give us money. Like, we need to fight this, give us money.
Oh, interesting. Yeah.
Yeah. And like everyone else that I talked to that I would kind of consider, they're like, yeah, whatever. Like, nice.
This is like this is a separate thing.
Yeah.
No,
totally
so
anyway.
Climate alarmism is a problem, and I think that there's an opportunity for states' attorney generals to actually sue those groups. And they might say, oh, it's free speech, we're talking about a political issue, you can't sue us for causing this alarm. It's not free, it's commercial speech. You're making money. You're saying the world's ending, give us $1. That's now commercial speech, and you actually can be held accountable for lying. And so I would put this stuff into the same category, and this is going to get, it's just for analogy in 2025. But, the other huge controversial political issue right now is the whole, like, WPATH transgender medicine. It's suicide or surgery for kids to get their gender transition, air quote, surgeries. So that science was totally debunked. Totally debunked. And they were using all this alarmist language like suicide or surgery. And then when all that science was debunked, the emperor has no clothes and they're radically exposed. That is the equivalent of what's happening here in the climate change movement, except climate change is a lot more complicated than like your kids, right? And so what's happening here is the Trump administration is saying the emperor has no clothes. This is fake science, and that's not hyperbolically being said. And all these arguments for 20 years that you're a client denier or you're a human being have been completely undermined by how the average person's been treated by the so-called experts. And so there's just a lot more natural suspicion. And so it's still going to be really hard to undo something because there's so much public support. And so I think legally speaking, the EPA is definitely within its own jurisdiction to be able to propose a new rule, to say, here's our new finding, here's why we think what we think. And if it was over like any other topic, it would probably have really no problem. And it's like, great, yes, EPA obviously can do research, things change in 20 years, and can then change its position on a substance. That does it all the time. I think part of why it's such a huge deal for the endangerment finding is because it's a climate change.
Yeah.
It's like, and this is part of why why is it called the endangerment finding and not the climate change finding? Because I think that the people that support it don't want the public to know that actually the whole climate change science thing is under such tough scrutiny. Because they know that it's weak. They know the science is weak. They know there's a ton of climate alarmism, and they know that if it's repealed, there's going to be a lot of exposure. And groups like the one that emailed you saying, the sky is falling, give us money, those groups can be held accountable by state government officials for essentially fraud or like consumer protection for lying, knowing or should have known that the science is bogus. And it's going to help topple the entire sort of climate change fundraising NGO machine. So the endangerment finding coming down is going to have huge cascading effects for the climate change movement. This is the science that they use to defend what they've been saying and doing for so long. Now, it's also going to be hard to overturn in some ways politically, because there's groups like major oil companies, like Exxon's comments to the endangerment finding. So the public can comment. So the agency puts up, we're going to rethink the endangerment finding. Right. And they give a certain amount of days determined by law and determined by something called the Administrative Procedure Act that says you say 90 days to comment, or however many days to comment. And then anyone can comment, and then the government has to respond in kind to every single comment. So Dan Romito could be like, I think that climate change is actually caused by marshmallows, and they would actually have to respond whether or not that's legitimate and put that in the record. So they have to consider every single thing. And so when the Trump administration said, we're going to reconsider this, they, wanted, my law firm commented on it. We represented a Midland oil and gas company we actually discussed the climate alarmism issue in our comments. But basically, a lot of companies said that we actually only want to take a scalpel to this. We don't want to completely overturn it. Part of that is because they've already spent so much time and money over the decades on having to address this stuff in their rulemakings and in all the things that they do with their business and their operations. They've invested billions of dollars in like carbon projects and carbon management. I mean, it's like we're so far down the road. Part of it is they're afraid that if in 2 years the Democrats take the White House again, or in the midterms in November, the House and Senate, there's just so much back and forth. There'll be retribution to anybody who challenged sort of the climate regime. And so a lot of industry, very reasonably, their comments have been a lot more moderate or modest, because they're sick and tired, and they're frankly afraid of the government. They're afraid of the pendulum swing. So again, if this is going to be upheld, it's going to be by a court that's willing to just look at the law and say, yeah, this looks like they did their work. The science looks like there's plenty of reason to doubt it. The EPA has plenty of new science that says this is problematic and why it shouldn't be regulated this way. Right. And they're going to ignore the public sort of spectacle. Because, starting yesterday when this thing got published, it's going to be constant pushing, constant emails, Dan. Like, you just got an email, guys, right? So people clamoring. Your kids are going to be, if they're like in school, they're going to be coming home. Mom, I just learned, about the skies falling or whatever, depending what school your kid goes to. It's just going to be, so the courts are going to have to be willing to really take that, justice is blind, air quotes, because it is a big deal that this whole thing is being challenged.
Well, what's interesting, like I had Judith Curry on. She was one of the authors of sort of the updated DOE report that Chris Wright put in place. And, she has been labeled as a climate denier. And she's got this fascinating story about sort of her falling out with Georgia Tech because of her stance on certain environmental related issues. And after talking to her and certainly reading like what she puts in the public domain, she does not say there isn't climate change. She actually goes out of her way to say, yes, the climate is changing. Her argument is that this is actually something that we can address and we can adapt to, but it doesn't make any sense scaring the living crap out of everybody and then bankrupting ourselves to sort of make a slight dent in global temperatures, which we wouldn't be able to accomplish anyway, because as you pointed out correctly, the other actors around the globe, right? So one of the things that absolutely drives me nuts, and you hit it right on the head, is like this alarmism is that, you don't think that this is a thing. It's like, no, I do. I'm just not going to lose my mind over it, because I think that we're technologically savvy enough and innovative enough and frankly smart enough where we can either adapt to it or that we can mitigate it. And if we're going to decide to bankrupt ourselves, then there's no money to do anything, right? Then we have no economy, we have no national security, we have nothing, and then what are you left with? Which brings me, I was going somewhere with that, which brings me, the report that they released, like that DOE report, do you think that is sort of the next wave of where you just have these experts kind of cluster and have them duke it out, and the court sort of cherry picks on like the most efficient or effective arguments? Or do you think this is going to be something like we've seen with other cases where depending on what district or depending on what judge, it becomes sort of like this tribalistic sort of butting of the heads?
So I think that it'll be, of course, a little bit of both. I mean, the experts you're talking about, Alex Epstein, there's a few
Yeah.
others, they've been arguing for years that if climate change is real, it's not so drastic, it's not the numbers you're saying or how. The consequences of it aren't going to be what you're saying or how, and we all know that. When I was in kindergarten, it was the rainforests, and then it was the
Yep.
ozone. Remember, there was these holes in the
Yeah.
ozone. We're all going to
My sisters
incinerate.
were like on super depressed because they couldn't tease their hair with the hairspray. Got rid of it.
100%. Aquanet got like majorly
Yeah.
overregulated. You have to go to special markets to get your Aquanet. So
The black market for
the
Aquaman.
black market for hairspray, you can get it in Texas, pretty much anywhere. I'll have you know. But yeah, I mean, it's pretty outrageous, right? That there's always been alarms. Fear is a huge incentive, and
Right.
you really can pay, anyone can pay most any scientist or academic enough money to do a report that says whatever.
Yeah.
I mean, that's just highly cynical, right? I mean, I'd like to imagine every single scientist is always only bound by the science and not the money and the funding. But I think a lot of that's become unraveled. And you
Right.
have these experts like this, I can't remember her name, from Georgia Tech. It's just,
Judith?
you just said it. And then like Alex Epstein. But there's a
Yeah.
bunch of other guys out there and gals that are saying like, we're not saying this isn't happening. Like, obviously, like it's super hot this summer or this or that.
Yeah.
It's just humans can adapt, and the
Right.
government can't fix everything, and certainly not the federal government.
Right.
And so anyway, you're making like super reasonable arguments, Dan, that like aren't always what wins today, unfortunately, in these cases. So I will say, so to address your question, science versus statute. Like, what is it that's going to win the day here? What's going to actually win the day, besides the scientific questions and the modeling and like X, Y, and Z that you're talking about, very practical, it will also be the agency procedure. Whether the agency, when it overturned the 2009 finding with this 2025 version, whether they rigorously adhered to the correct procedure. So first, the scientific record. So there's a record the agency has. It'll be fought over because the finding is informed by science. So that's part of the science, but it's an evaluation of the science rather than the science itself. It's kind of a confusing distinction. Opponents are going to say the evidence supporting endangerment, supporting the finding that CO2 is killing everybody, that it's only strengthened, right? And they're going to say there's new studies and new evidence. And the agency and its supporters will argue correctly, in my opinion, so the Trump admin, that the prior rate record was overstated, that there's a lot of uncertainty, that attribution issues, like attribution science is something you'll hear a lot about, but where you're attributing this to is not properly treated. This goes back to your arguments. Is it really anything in the U.S. that we can do? How can we attribute this to a plant in Kentucky? It's global climate change that like 85% of it's from China and the rest is from India. So like really the attribution science, I think, is something that's really been challenged. There's been a lot of overstatement, and the framing of the finding improperly blurs legal standards with policy. And I won't get into that on the pod because it's hyper legal, but basically there are legal arguments that the way that the climate alarmists have framed it is blurring legal standards. So we kind of need the courts to step in and make these legal distinctions over the procedure record. The second thing is that statutory interpretation is going to get fought because greenhouse gases are a very awkward fit for the statute that's built for local and regional air pollution. So the original statute, again, built for local regional air pollution. So supporters who want to rescind the rule and have the new rule are going to emphasize congressional intent. They're going to say the limits of using the Clean Air Act to regulate this extensively. They're going to say the EPA has already implied it believes it can't regulate greenhouse gases under the Clean Air Act. And so those will be arguments. And then opponents are going to say the act treats, health and welfare very broadly. They're going to make these Massachusetts versus EPA arguments that won the day in that court. So it's going to go back and forth. And just remember, even if EPA concedes that CO2 is an air pollutant, so even if they make a concession like that, which I hope they don't, but they could, the Clean Air Act requires EPA to judge whether CO2 causes or contributes, that's the second rule, the cause and contribution to harms to health. and whether it
Okay.
contributes to endangered health. So EPA can say that GHG emissions from a vehicle, for example, are a drop in the bucket. They don't substantially impact global climate change, one car. That global climate change is no longer the threat to health and welfare it once was thought to be. But in court, as I mentioned, the decisive question is going to be procedure. Did they follow the right steps? Confront the prior record honestly, and make these legal arguments about that, like one car's emissions. So it'll be a mix. And I do think, though, at the end of the day, that we will win on procedure, so long as the court's willing to take a blind eye and just look at the record and procedure. I think what's the big unknown is, courts on both sides of the aisle of how they are sort of more and more willing to just do what they think is right, as opposed to like what does just a black and white record say. So This is the big question.
Okay, no, that makes a lot of sense. Yeah, increasingly you sort of see like the irony of, once again, I took one law school class in college, so it's been a hot minute, but like the whole objective of the judicial branch is to be the objective portion, and the emotional component is in the legislative and the executive branch, and it doesn't seem like that dynamic is in place on both sides anymore.
No, yeah, the judiciary is supposed to be the least dangerous branch in the Federalist Papers, but really it's turned out to be probably one of the most dangerous in our generation. So
100%. The other thing that's sort of driving me nuts too, and once again I've had several conversations already on this in the last week. I'll take the pulse of people who are very, I would say, skewed towards climate alarmism as opposed to climate pragmatism. Because I just want to hear what they have to say. Certainly, I don't agree with everything they say, but it's interesting to hear like their argument. And one of the things that keeps coming up is like, oh, this is to save the butts of oil and gas, and it was like, no, like you have vehicle standards, that's the auto industry. You have power rules, like once again, the generalist, if you will, just Joe Peep or Joe Q public conflating energy and power, and then sort of the industrial permitting. So, from that perspective, whether you have autos, let's call it power, and then the industrials, are those going to be equally impacted all at the same time, or is there one is going to get preference? It sounds like auto kind of has more of an immediate benefit, or how do we think about how that rolls downhill to the other non-oil and gas industries?
I think no question the most immediate effect will be in vehicles. Just the cars. But, we use the word vehicle when we're lawyers, and the vehicle rules. And so the endangerment finding is the predicate for greenhouse gas standards for new motor vehicles and engines under the Clean Air Act's framework. And so this is huge. If the findings rescinded and paired with a rescission of with the vehicle greenhouse gas standards, there will not be instant calm for regulated entities. It will mean immediate litigation. There will be public outcry due to the climate alarmism that we're talking about. And that's, in some ways become a accepted part of daily life, this climate alarmism. Yeah. So there's just going to be people really speaking out, and then uncertainty as to how they should respond when manufacturing and selling products in the market. So states can respond also, and this is something we've consistently seen. When we draw back a regulation on the federal level, certain states will then just double down, triple down. Yeah. And so we see, like in California, for example, they have their own entire regime now on all of this. Right. So greenhouse gases have been the most consequential. So in permitting, so we'll pivot to permitting, when facilities are already in a conventional like pollutant permitting program and controls for greenhouse gases are evaluated. So like Title VII air permits. Yeah. And so the way that greenhouse gas comes in is they're required to use the best available control technology for emissions. And so it'll affect what technology they're using to control emissions and whether they have to have technology in their processing facilities that manage greenhouse gas. So imagine they have to build a $500 million a piece of equipment that's going to regulate how much CO₂ is emitted, how much air is released. Okay, again, imagine if the EPA decided to control water vapor. Oh, you can't put that much water vapor in the air. It's going to really ruin the entire planet. And you're like, really? My one plant in Kentucky? My one plant out in West Texas? Right now, the clean air, the way it's done is yes. And so we take that away. But then there's litigation. The environmental groups will say you're not meeting your air permit requirements and da 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 da. I mean, there's just these shifts back and forth. You have to really you have to understand the regulated community. Like, it makes sense why major global companies sometimes just want to stay out of it, or they want to go for a scalpel and not because it's so hard to manage it. But anyway, shifts in the federal regulation, I think, are going to affect the vehicles immediately the most, and then I think it'll be permitting through this best available technology.
What about, so you kind of touched on it too, California, to me personally, is just a head scratcher on a variety of different levels, right?
Yeah.
I struggle to understand where they are coming from, and frankly, I've sort of given up on it. But because this is obviously a federal thing, California and Washington, New York, Illinois, they can still do whatever they want? Or does this federal ruling sort of give a little bit of ammunition to sue those states to align or to sort of revert back to what the federal? How does that dynamic work? I don't understand that.
Well, in some ways, I think the certain states like California are just looking for an excuse to do more regulation and the political will. So they don't want oil and gas in their state, right? They would rather people walk than drive, and they would rather towns be small enough to where you don't need to have cement. I mean, that's just true. I mean, this is not hyperbolic. This is what they say. The whole modern economy is just, it's not utopian enough. They want to go back to the Garden of Eden. And so it's sort of this, any excuse to get there and to feed the frenzy of the public's fear to sort of enable that. I mean, it sounds super cynical on my part, but at this point I've been litigating these cases for so long. I'm like, this is the playbook. So you're going to continue to
listen to the stuff.
Yeah, you're going to have states do it, and we do climate change litigation. We have lawsuits challenging climate alarmism. So my law firm's in the weeds on the science. We're in the weeds on how this works. We're in the weeds on the NGOs that do fundraising on it. And so anyway, I think that the states are going to continue to do that. Plaintiff bar is also going to continue to work. They're going to do what they're going to do. They're going to look for ways to sue the companies and what are new hooks and strategies. There's actually a really good case right now called Suncor Energy versus Boulder County. It's a case on appeal to the U.S. Supreme Court. And it's asking whether state tort law can be used by localities to regulate out-of-state activity. So let's say you can't regulate out-of-state activity through the endangerment finding or whatever. Well, now can the local municipalities can do that? So Burke Law Group, we wrote a brief in this case asking them to take the case up and arguing that federalism grounds prohibit using state tort law. So the state of California can't use the state laws on, nuisance against the company on these types of grounds. But these are things that are going to be challenged, and we're going to figure it out. And that some of the arguments that have been made by the government in establishing the endangerment finding have been, it curbs tort litigation. So once you take that away, are you allowing tort litigation? I don't know if this kind of answers your question. It's just sort of these secondary effects. The states are going to double, triple down. The plaintiff bar is going to double, triple down. And so oil companies are going to be defending themselves one way or another in court, So what we should be really thinking about is long-term consequences. So maybe there's going to be a lot of immediate problems. There's going to be a lot of immediate pushback. There's going to be a lot of immediate, issues that people have. But I will point you to, I think what's really interesting, Steve Malloy is a biostatistician and environmental lawyer. He was the former Trump EPA transition team advisor. He's a senior fellow at the Energy and Environmental Legal Institute. And he just recently told the Washington Post that, gas prices are going to remain low and car prices are going to decline. So EPA put out messaging that it estimates the benefits to the economy from rescinding the endangerment finding for vehicles alone will be $4.7 trillion for 2027 to 2055. And he says this is a gross underestimate because gas prices will remain low. Car prices are going to decline because of this. Lower gas prices and lower car prices will ripple through the economy for decades. And so he's those types of trickle-down effects from lower gas prices and lower vehicle prices are not quantified in the savings, which is already at 4.7 trillion. Plus, the cost of regulating greenhouse gas is incalculably large. And so it's like a psychological thing. A lot of these companies are saying, we've already spent billions. And it's like, guys, if you continue, it will be trillions.
Right.
So I understand you've already spent a bunch of money on a bunch of overregulation, but if you don't stop the bleeding, it's only going to get more expensive. And so these are the types of arguments like Steve Malloy's been making.
Yeah.
That, you have to frame a major deregulatory move with long-term savings and not only think about the opportunistic plaintiff bar today and not only think about, whatever litigation might be in front of you or whatever it is, some state like California. We're going to have to address that eventually.
Okay.
But if we don't do anything and we just continue to allow them to regulate things like carbon dioxide, well, what's stopping them from regulating air or water vapor? So anyway, it's tough. It's tough. I mean, it would not be honest to say, oh no, it'll be great, everything will be rosy once we get this thing passed. No, there's going to be problems. So
yeah, I like the Malloy argument. I have to read it, but conceptually, I agree with it. It's like if there is a problem, like you take any problem that we've had, like major problem, perceived or real, like put that aside. Like the solution that's always been the most effective is a bottom-up market. Like you had some really smart entrepreneur that got some financing, that provided some service or some technology that fixed it. And you sort of just let the market do what the market does, and you let these entrepreneurs, like these really smart people, kind of just innovate. And then I don't, and I'm getting a little bit preachy on this, I've never seen an instance where we've regulated our way into an effective long-term solution, right? I was just in Europe for an event. I was in Italy, and it's just so weird to me. Once again, I guess I'm judging, but it's just weird to me, like the compliance mindset that they had. Like I was walking down the street from my Verbo to the hotel, and there's a stoplight, and it's like a do not walk sign, like the standard do not walk. There's not a car for like a half mile. Like there's no car in visible sight, and I walked across the street. I disregarded like the stop, and like these European dudes are like, oh my God, like how could you do that? And then like another example was like, I was with some of my buddies, and it's like 7:45 in the morning, and we're hungry and a little groggy from the night before. I'm like, man, I want coffee. So we go to the coffee bar, which is fully operational, like it's there, and they're like, no, you can't have coffee until 8 a.m. We're like, it's 7:50, and I'm perfectly capable of pouring my own coffee. And the guy was like, no, like I can't give you any coffee until 8. And it's like, give me the goddamn pot, dude. I'll do it myself. And once again, like they just the mentality.
You have a cigar over
and
you need coffee, Dan. We know.
Right.
We know.
Like, give me the coffee, dude. But my point on that, like the compliance mentality is so restrictive and such a constraint and such an impediment to like solving problems. Like granted, the problem was I was late, so I had to cross the street, and I was slightly hungover and hungry, and so I wanted the coffee. But it's a great example of like, dude, just like don't worry about all these rules. Like a general sandbox to play that ensures like fair competition and like that you don't break the rules. Do you think that this is sort of an inflection point of like convincing people that that's the way to go, or do you still see like the compliance mafia raining down like their overreach on this? And once again, I'm not saying you shouldn't have rules. Like that's I'm not going to the extreme. I'm just saying like guidelines are a little bit better than sort of like a laundry list of rules.
I think that with the endangerment finding, it's still the public doesn't know what it is and that what's happening the way they would know with other things like the WPATH science for kids. Like the way the headlines read, it says endangerment finding. It's not climate change. Science under question, really. I mean, and so it's and so I don't know. I don't know if it will be a turning point though, whether people know about it or not, depending how the courts rule on it. And if the rules rescinded, there will be downterm effects. So we'll see. And again, let's say there's a Democrat presidential, White House in 2 years. Well, they can try to do their own endangerment finding again, but again, it is going to be really hard for them at that point. Really hard. But we see that. We see that with like Waters of the United States, WOTUS. That was a Clean Water Act. Can a puddle in your backyard, Dan, be regulated by the EPA? And it was like yes, no. We're back to no. And so those were huge findings. But you know how we won on that? By being able to explain to the public that the government wants to go in your backyard and regulate what a puddle is.
Right.
We haven't been able to quite do that on this issue. I think a good way to do it is saying they're trying to regulate air the way they're trying to regulate water vapor in the air. That's the closest, but that's even a little complicated, more complicated than a puddle in the backyard. So I think that we still have our work cut out for us on sort of just like explaining to the general public. Because at the end of the day, the courts kind of, I do think, rule on what do they think is going to be the public opinion and all that. They take into account the like enormous role that, media, press, social media, all that stuff plays. And what's the public response going to be? They see it as credibility of the judiciary. And and I think some of these judges think, democracy is being held on their shoulders if they don't rule a certain way, those ways typically always end up being against, I would say, common sense on these types of issues. But yeah, so I don't know if we're at a tipping point or not.
Okay.
I don't know if it'll be just more back and forth for the foreseeable future.
That's my fear is like the back and forth, once again, to implement like an effective strategy, particularly from a business standpoint. I totally hear executives' frustration, regardless of where they stand. They're like, I would just like some certainty. Like it's really, really hard to run a business when there's this much volatility in the market. Now, once again, the result of that is just create a strategy that to the greatest extent possible makes you immune from the regulatory winds. And I haven't heard one oil and gas executive or client say, well, we're going to change everything. They're just steady as she goes. My assumption, and once again, like you tell me, this is going to be drawn out for quite some time. Like this is not something that's going to be settled in the distant, in the short term.
No, I think they get challenged immediately. There'll be litigation immediately, so it'll be, is this final for the next at least year or so? And then there'll be states pushing back. And like we said, the plaintiff bar filing lawsuits. And then we'll see about that case. We have that Supreme Court case. I mentioned about whether states can use state tort law to regulate this stuff in the absence.
Yes.
So, all this stuff, it's just going to continue to be litigated. There's an entire industry. There are thousands of lawyers. Their entire job is these issues and to keep them alive, So, I'm like, people, this is totally tangential, but I'll get there. The legal industry worries about AI and like, how's it going to affect the legal industry? Because it's going to replace like half the lawyers. And I'm like, yes, good. We do not need more lawyers. We do not need more, because all the lawyers that don't get jobs in big law firms and they don't get jobs in-house for companies, they go work for the government or they go work for NGOs.
Yeah.
And a lot of people now, they go to law school to go work for governments or NGOs. You have true activists going in and seeing this as like part of, they really believe, they've been raised, they believe the stuff that we never really believed because our parents told us better. But they believe this stuff. They are scared the planet's ending. They believe carbon dioxide is a poison. Can you imagine, Dan, if you really of your entire life believed what you're breathing is killing you?
Right.
It's a poison.
No, like that's the distinction too. I was talking. We have some, clients where they're a little bit younger, and they'll make the point of like NOx, SOx, VOCs, a variety of other sort of pollutants. And my thing to them is like that's not what this is necessarily about. Like, and I'm glad
the average person just knows CO2.
Yeah.
The average, and what's CO2? They Google it, air. It's like they if they take a step back, they're like, air's killing me. It's like carbon. Carbon is the basis of all human life. I remember learning that carbon and saying that carbon is killing is a toxin. Yeah. And then the next thing is, of course, water vapor. That's why I mention it, because just mark my words, I'll be on the pad one day being like, well, now that carbon is pollutant and air is a pollutant, what's left? It's like all the foundational elements of human life.
Right.
You know, so I don't know. There's this entire industry around these ideas, and people sincerely believe it, and
Yeah.
they're invested in it whether they believe it or not. And so no, it's not just going to go away. It's way too big. It's way too big, and so it's just something that industry has to decide how they're going to manage it, how they're going to, So the Trump administration here heard comments from industry saying Overton window, far left, do everything you can, and we'll take whatever win we can. And they also heard comments from industry saying, please take a scalpel to this, for the love of God. We
Right.
have put trillions, And so the government has to take all those comments, respond to all of them, and what they've decided is full Overton window. We're cutting the cancer out. It's chemo and radiation and surgery.
Right.
And so we're going to really try to end this thing, and sort of very Trump, classic Trump. It's sort of like come what way, whatever collateral damage. Sorry, you'll figure it out. You guys are smart.
Right.
It's really the bigger companies that have invested more over the years in buying into the climate change stuff because they've had to, or maybe they believe it. But they're also the best positioned to figure out how to adjust. It's the small independents, it's the mom and pop companies. They're the ones where they're like, I cannot survive because of this overregulation. And so Trump decided, he's a populist president, and he decided to err, on the side of the little guy and say, listen, we're cutting these huge rigs out.
That's what I appreciate. Maybe the most, if I'm being honest, right? I mean, I'm a little bit biased on this just given the nature of the people that I work with individually, but I think the waste emissions charge or the methane tax, whatever you want to call it, was a great example. It's like, we have to regulate methane. It's like, okay, like walk me through this. Well, methane is this incredibly toxic gas that is being released into the atmosphere with all these consequences. And once again, I'm not going to debate that methane isn't toxic. It is. I'm not going to debate that there aren't leaking wells. The data says that there are. But if you're going to bankrupt the companies who are running this, you're just going to end up with more wells, leaking wells. So I never understood, or I never was able to connect the dots where you bear these compliance costs and once again, it was public. Like we want to regulate them out of business, which then, okay, well then no one is going to oversee these wells, and all of them are going to leak, and then we have a real big problem on our hands. Like, why don't you just provide much more of an economic incentive? Like, once again, the running joke. Like, if you told Exxon, or frankly anybody, I'm just going to pick on them because they're the biggest. Like, if you guys figured out how to, and could prove it that there would never be any methane leaks ever, and you never had to pay taxes again, guess what? They would figure it out tomorrow, right? There's that incentive in there. Back to our point earlier, I'm getting a little bit preachy, but what you just said, I mean, there's a real life example. Like, the waste emissions charge didn't work, not because we wanted to spew methane into the atmosphere like it was going out of style. It's that the resulting consequences would be you're going to bankrupt a disproportionate amount of smaller players who are just going to walk away because they don't have the capital to reinvest in the wells. Anyway.
No, you're right.
Well,
And those are the types of arguments that were made on the methane finding when they did those rules, and those are the super practical arguments that have been made on the endangerment finding on how this is going to affect, just practically speaking. Like, fine, like you're saying, let's say climate change is real. I mean, there are radical changes in the climate. Sure, is it caused by this one plant?
right.
So the plant who has to get the permit, who has to put the best available technology to eliminate something that, even if their plant didn't exist, wouldn't put a dent at all.
Yeah.
Even if every plant in America, ceased existing, wouldn't put a dent. But you still have to pay those hundreds of millions of dollars. It's a farce, So these are the practical things you're saying, Dan, that I think we have, and it's not every day you get to take cases where you're like, I just really believe. I mean, I am personally, I was in the EPA for Trump 45, right? Like, the endangerment finding has always sort of like been so frustrating to me because the public's never understood how crazy it is and how bad the science is. And we were called deniers for asking like basic questions about modeling and about, this idea about, well, what about China? It's like climate denier. You're like, oh my gosh. So we're finally like sort of being heard.
Yeah.
You know, like the
Yes, it
mask
does.
is sort of coming off more, Dan, and it's so fun as like a lawyer to actually have a case that's like, oh my gosh, all these years of litigating are kind of paying off. Um, but yeah, I mean, people, it is these practical arguments I think that are winning the day. I mean, it's
Yeah.
finally resonating. The oil and gas industry, I think, is doing a good job of getting the message out of what this is. But yeah, it's not always. Yeah, the public still doesn't quite understand.
Yeah. I think we're getting there. It's getting a lot better. Like I remember being a little bit hesitant to get on stage to talk like 4 years ago. Like, am I going to be chased out of the room with pitchforks and knives because I was saying natural gas is a decarbonizing technology? And then today people are like, natural gas is pretty cool, right? It was like, yeah, like we've all been for like the last 4 years.
It's true.
This
You
has
got
been
to get
great,
up there.
Marcel.
You'll know you're sort of like really red pilled when you get up there and talk about how great coal is for the economy. That's when we'll know,
Oh
Dan.
God.
Are you a real? Are you a real?
Look, I did. I released. There's and this is like 3 years ago now. I did like a series. It's American coal is cleaner than Chinese solar.
100%. I know.
Yeah,
I love
and
it.
once again, it wasn't hyperbole. It was just going through like the supply chain data, and then some people like lost their mind, and like
I
some of the
know.
messages I got were like you didn't read what I put out. Like I did a crafty title so you would actually read it. And then the people who did read it, like to their credit, even though they didn't like coal, they're like, yeah, it makes a lot of sense.
Hmm.
This has
Hmm.
been awesome. I can't thank you enough. Like once again, you did
Yeah.
this on such short notice. You have a new baby, you have a law practice, you have all these things going on. So to take the time, I appreciate it. I gotta have you on again in the not too distant future. So Marcella, thank you so much for joining.
Thanks, Dan.